appeal in the matter of Holbert portfolio of UK Limited in Ruhan.
Mr. Garland.
My Lord, in this matter, I appear with my learned friend Mr. Coquelar and Mr. Ryan for the appellant, Mr. Stevens, and my learned friend Mr. Pickering and Mr. Hodge appear for the respondent, whom I shall refer to as HP2. My Lords, there's a great deal of material to get through. Your Lordships, I know, will have done a considerable amount of reading already. I'm happy. I just want to make clear I'm happy to be told if there's a matter that I don't need to take your Lordships to. I'm more than happy to move on. But there, as I say, there's a great deal of ground to cover.
There is a great deal. At the same time, I don't suppose it's necessary to turn up every case in the 9 volumes of authorities.
I'm delighted with that indication. Your Lordships will appreciate the amounts at stake, first of all. You'll see from the order, which is at the judge's order, which is at tab 6 of the core bundle. Mr. Stevens was ordered to pay £102.26 million by way of equitable compensation, and he was further ordered to pay a sum just shy of 60 million by way of compound interest. And there are appeals against both of those orders. The key facts from which this appeal arises is summarised in the skeletons, but essentially the nub of HB2's case is that in breach of his fiduciary duties to HB2, Mr. Ruhan, its director, caused the company to sell 3 hotels to a Madeiran company called Cambulo. Cambulo was ostensibly owned by Mr. Stevens, who HB2 alleged, and which the judge found, was actually acting as Mr. Ruhan's nominee, so there was deception. Mr. Ruhan's purpose was to make a secret profit for himself, and I emphasise for himself, for reasons which will become clear later on. And Mr. Stevens thereby assisted Mr. Ruhan in doing so. Some points about the claims advanced by HB2, in particular a claim that didn't succeed, the conspiracy claim. Perhaps I could ask your Lordships to look at the core bundle behind divider 12.
Is this for the judgment or for something else?
This is for the particulars of claim. I'm going to seek to explain by reference to the particulars why the conspiracy claim failed. If I could ask your Lordships to go to page 294. The conspiracy plea is in paragraph 79. Further, it's alleged, in all the circumstances, Mr. Ruhan and Mr. Stevens conspired to defraud HB2 by together agreeing to enact the self-dealing arrangement set out above and or to divert, and I'll skip over the words, the development opportunity away from HB2 to other entities which on their face appeared to be unconnected to Mr. Ruhan, but of which he was in fact the ultimate beneficial owner. And then in particulars, you'll see in paragraph 1, there's an indication of how Cambulo was set up in order to give the false appearance that it was Mr. Stevens who was its UBO and controller and that Mr. Ruhan was not connected. Secondly, Cambulo was set up as above in order to enable Mr. Ruhan to secretly self-deal through the Cambulo group sale and or procure the diversion of the development opportunity away from HB2, skipping over the brackets, to an entity or entities of which he, Mr. Ruhan, was the sole or principal UBO. And then we skip down to the particulars of fraud. Paragraph 3, the above acts were carried out with a view to depriving the creditors and other shareholders of HB2 of the development opportunity and the benefits, profits and gains which flowed from it, and or to allow Mr. Ruhan to reobtain a significant interest in the Hyde Park hotels and their proceeds once they've been on-sold by HB2. By its very nature, such diversion and or self-dealing must have been carried out knowingly with an intention to defraud or recklessly. Lord, the reason why I draw that to your Lordship's attention is that it's made clear in the conspiracy claim that the gist of the complaint is that Mr. Ruhan wanted to make a profit for himself. And if we go over the page, paragraph 80, by reason of the above, HP2 has suffered loss and damage. And then the particulars of loss and damage over the page, no less than 102.26 million, being the loss of profits or gains arising from the self-dealing and or diversion of the development opportunity, which ought to have been accounted to HP2. So I do pause to note that the alleged conspiracy was not simply to enable Mr. Ruhan to make the profits for himself, but to conceal them and keep them from HP2. Now, the claim failed because the judge found that HP2 failed to show that it had suffered any loss, and there's no appeal from that finding. In his judgment, this is at paragraph 249 of his judgment, for your lordship's note, it's at page 183 of the bundle. No need to go to it directly. The judge noted that the difficulty with HP2's case on loss is that it had not sought to advance any case that it was paid less than the market value for the hotels, that if it had not sold the hotels to Cambulo, it would have sold them on more favourable terms, or that it would have exploited the opportunity itself. Rather, the loss claimed was the loss of profits made by Cambulo from the on-sale of the hotels. That claim was premised on the defendants carrying out their conspiracy to the point of realising their profits, and then somehow embarking on a new conspiracy to cause loss to HP2 by not accounting for those profits. And the problem for HP2, of course, was that was not the conspiracy that was pleaded. And that's the point the judge makes at paragraphs 251 to 254 of his judgment. As the judge concluded, HP2 pleaded a single conspiracy that involved the making and the use of the profits for Mr. Ruhan's purposes, which meant that it could not claim damages to put it in the position it would have been in had the profits been made but not accounted for. I should make clear, and it's important that I do make clear, that that was not just a pleading point. You might think that from the judge's judgment. The fatal flaw at the heart of HP2's conspiracy case was on the facts, as the judge found them. On those facts, what Mr. Ruhan was seeking to do, with the assistance of Mr. Stevens, was to make profits for himself and to keep them from HP2. It was, in fact, not as a matter of pleading, but in fact, a single scheme. And in my submission, no amount of fancy footwork could have turned it into two separate schemes. It would have been artificial and unreal to try. And your lordships will obviously appreciate why I'm saying that and using the terms artificiality and unreality. Now, turning to the dishonest assistance claim
just
against...
Before you do, I mean, the judge obviously ultimately rejected the unlawful means conspiracy claim, but he accepted the dishonest assistance claim. He didn't think that the basis on which he had rejected the unlawful means conspiracy claim fed through to the dishonest assistance claim. You say it's not just a pleading point. Did not the judge really see it as a pleading point?
Lord, in my respectful submission, not. I'm in danger of repeating a submission I've already made, however.
Yes.
Maybe you've already had all the assistance I can give you. But the reason why the judge was able to find that Mr. Stevens was liable in dishonest assistance was because he was able to construct an elaborate argument based upon the fact that Mr. Ruhan was a constructive trustee of the profits, that he therefore breached a custodial duty of his breach of trust. Your lordship obviously understands that. The simple fact remains that if one tried to transpose that in, perhaps I could answer your question this way, if one were to try and transpose or use that fact for the purposes of pleading out a decent, workable unlawful interference claim, one would have to say there was a conspiracy to create a constructive trust, and then a second conspiracy to dissipate it. And in my respectful submission, that the ludicrous nature of that proposition, those two propositions, demonstrates the unreality of HP2's case on unlawful on conspiracy, because there was no separate purpose to make a profit in the air, in the abstract, as it were, leaving it open as to who would actually have the profit. And then a second conspiracy, in order to, having made the profit, to grab it for himself. It was always going to be Mr. Ruhan's profit for his use and enjoyment. And that means that, as I've already submitted, no amount of clever footwork could have avoided that essential problem. There was one scheme and only one scheme, and one can't, without artificiality, separate the making of the profit and the enjoyment, and the having. While I was preparing my submissions, I kept trying to think of a witticism about having one's cake and eating it, but it's the wrong distinction. It's between the making of the profit for himself and then the having of it for himself. That's the distinction that arises in relation to dishonest assistance. And it arises only because of this curious feature that equity imposes liability to account under constructive trust. I hope that answers your Lordship's question. Now, if one goes to page 296 of the pleading, this is dishonest assistance, paragraph 82 of the particulars of claim. Where I'm going with this is that HB2 advanced essentially the same case of loss in respect of dishonest assistance. Paragraph 82, perhaps I could ask your Lordships to read it to yourselves.
Yeah.
HB2 alleged that by having received the profit and or by having assisted in the breaches of fiduciary duty, that is the director's breaches that I've already shown your Lordship to, Mr. Stevens was liable for knowing receipt or dishonest assistance. Particulars of his assistance are related in subparagraphs 1, 2 and 3. Perhaps it's worth looking at some paragraphs, and dishonesty is in 4. Paragraph 1 alleges that Mr. Stevens acted as his companies acted as a nominee, and that for Mr. Ruhan, and perhaps 7 or 8 lines down, and in that way received it, the property of HB2, and any profits and gains earned by Mr. Ruhan from the same, knowing that such a receipt arose out of the diversion breach, and so on. So there's an allegation of receipt of the profits. And then in paragraph 2, that it said that these things necessarily involved Stevens acting as the owner and controller of Cambulo. It's axiomatic that such acting knew that Mr. Ruhan was acting in breach and contravention of his duties, and that he knew he was receiving the proceeds of such breaches or contraventions. And then paragraph 3, by so acting, and in assisting him as regards the control and actions of Cambulo, by receiving the profits and gains earned by Mr. Ruhan of his breaches, Mr. Stevens assisted Mr. Ruhan in carrying out some or all of those breaches or contraventions. My Lord, and then there's loss alleged in paragraph 83. It's alleged that by reason of the above, Mr. Stevens is either liable to account for any profit or gain made, or he's liable to compensate for HB2 for any losses suffered. Your Lordship will see there's no explanation as to what the loss actually was, no particulars given, just as in conspiracy. Yet, although the pleaded loss took the matter no further, the result, as the judge held, was different. And before explaining why, it's worth talking about Mr. Stevens' profits. The judge found that the benefits that Mr. Stevens received from agreeing to act as Mr. Ruhan's nominee included at least the sum of £500,000 paid to his company VTL in connection with the use of some shares as security for a loan. And secondly, the sum of £1 million that was advanced to Mr. Stevens and was never to be repaid. So what the judge found was effectively Mr. Stevens was paid a fee of 105 million. So stopping there.
1.5 million.
I'm so sorry, I must have said the wrong figure. Perhaps it was wishful thinking, I don't know. So Mr. Stevens' profits was 1.5 million. Mr. Ruhan's profits were 102 million. And for your Lordship's note, the relevant... Oh, I'm so sorry. I did have a note of the relevant paragraphs of the judgment, but I seem to have lost it. Is it 128? So paragraph 128 of the judgment is the 500,000. Paragraph 269 is the 1 million.
269.
I'm so sorry, my lord. I actually have a memory of writing that down this morning, and I do not know how I managed to lose that. But returning to equitable compensation, the judge began his judgment by referring again to the difficulty faced by HB2's case on loss. It had advanced no case that, but for Mr. Ruhan's breaches of fiduciary duty, it could have realised the profits made from the on-sale of the hotels or sold them for a higher price. Its compensation claim was based on the loss of the profits which Mr. Ruhan made, but for which he did not account to HB2. And the judge noted that the profits were themselves, or could be regarded as, trust property. Next, the judge considered whether, on the basis of the pleadings, it was open to HB2 to run a case based on the loss caused by Mr. Ruhan's failure to account for his profits once he'd made them, being dishonestly assisted by Mr. Stevens. The judge found that the breaches expressly pleaded by HB2 in paragraph 76 did not cause HB2 any loss. That's paragraph 272 of the judgment. However, while the judge found that the pleading didn't expressly formulate a breach of Mr. Ruhan's obligation to account for the profits and Mr. Stevens' dishonest assistance in breaching that duty, it was possible, by taking into account the different allegations set out in various parts of the pleading, to hold that it was open to HB2 on the pleadings to advance a claim in equitable compensation for loss caused by Stevens' dishonest assistance in Mr. Ruhan's retention, disbursement and failure to account for the profits. Lord, that's, for your Lordship's note, that's in paragraph 274 of the judgment at page 192. Retention, disbursement and failure to account for the profits.
Sorry, let me just find those words.
274. It's at page 192.
Yes.
And it's third line down. Mr. Ruhan's retention, disbursement and failure to account for the profits.
Yes.
Now, during the trial, HB2 didn't advance any argument as to why, as a matter of law, it could advance a claim for equitable compensation for the loss of the profits, which would never have been earned, but for Mr. Stevens' original assistance in Mr. Ruhan's breach. The legal basis for such a claim was...
My Lord, perhaps I could just say that's not actually accepted.
Oh, very well. In that case, let me make my submissions, and my learned friend can correct me. I wasn't present at the court below, as your Lordships may appreciate. But the legal basis for the claim, namely the reliance on the liability to account, the constructive trust, and the assistance in a breach of a separate duty, the separate custodial duty, that was raised by the first time by the judge, for the first time by the judge. It was raised during Mr. Stevens's, not Mr. Ruhan's, during Mr. Stevens's closing submissions. The legal analysis set out in paragraphs 278 to 289 of the judgment, which is the key part of the judgment, my first two grounds of appeal are challenging, is the product of the judge's own research and consideration after hearing evidence at the trial. Your Lordship will have read those paragraphs. Obviously, we'll look at parts of them. But the net result, as your Lordships will be aware, was although Mr. Stevens can only be held liable to account for profits which he himself beneficially received as a result of his dishonest assistance, so he's only liable to account for £1.5 million, he is nevertheless liable to pay HB2 the full amount of the profits which HB2 would never have made, in the sum of over 102 million, together with compound interest thereon in the sum of over just under 60 million. So that gives rise to some preliminary observations. I'm sorry to be so laboured about this. First of all, and to reiterate, Mr. Ruhan's original breach of fiduciary duty, his failure to disclose his interest in the sale of the hotels to Cambulo and so on, didn't cause HP2 to suffer any loss. This is not a case of a fiduciary misappropriating trust property for no consideration. HP2 received £125 million under the sale to Cambulo, and that price paid was never returned. The contract was never rescinded. It couldn't have been. HB2 would not have sold to other purchasers at a higher price, and it would not have pursued the development opportunity itself, and HB2 does not seek to argue otherwise. So the starting point for this analysis is that we have a breach or breaches of fiduciary duty causing no loss at all. Second, my second preliminary observation is that the claim in the tort of conspiracy against Mr. Ruhan and Mr. Stevens failed for want of any loss. The pleaded conspiracy was to allow Mr. Ruhan to make profits from the hotels for himself. I appreciate I've made this point 2 or 3 times as I've gone along, but now I'm making it again. It's worth emphasising these were not profits to be made in the abstract. They were not profits to be enjoyed by someone else. The essential object of the scheme alleged was that Mr. Ruhan would enjoy those profits. And the problem with the conspiracy claim was that achieving that objective did not cause HP2 to suffer any loss. So that's why the claim was dismissed against the 2 conspirators. Of course, that didn't end the claim, and here's my third observation. That didn't end the claim against Mr. Ruhan because he was a fiduciary. As a fiduciary, special rules applied to him, subjecting him to special duties, or it might probably be thought of as special disabilities. He's not permitted to put himself in a position of conflict, and critically, for present purposes, he's not permitted to make a profit out of his position without the consent of his principal. The result of those special rules was that even though there was no basis for holding that he was liable to compensate HB2, HB2 could hold him accountable for the profits he made for himself. And to support that liability, he held those profits on constructive trust, thereby enabling those profits to be traced and followed into the hands of third parties, who were not bona fide purchasers for value without notice. It's worth mentioning that Mr. Ruhan remained liable to account whatever he did with the profits. If he made profits on the profits, he would be liable for those too, of course. But if he dissipated those profits, that wouldn't affect the measure of his liability under his liability to account. The function of the constructive trust is not to preserve or protect Mr. Ruhan's personal liability to account. If profits are dissipated, that might technically be a breach of the custodial duty under the constructive trust, but a claim for breach of that duty would have added nothing to his existing liability to account. Having obtained an order making him accountable for his profits, HB2 was not entitled to an additional order making him additionally liable for the amounts he had disposed of. So the constructive trust doesn't give rise to additional loss, to new loss, for which compensation is payable. Taking into account the fact that by reason of his original breach, he's already liable to account for his profits, a claim for compensation for breach of the custodial duty would get HB2 nowhere. So if Mr. Ruhan makes profits of 100 million and he disposes of 90 million of those profits, he's liable for 100 million. He's not liable for 190 million. The 90 million loss, in inverted commas, suffered as a result of the custodial breach is subsumed by his liability to account, which the constructive trust is designed to support. What the trust is there for is not to give an additional basis for claiming loss, in other words. It's to provide a proprietary remedy in case the trustee, the errant fiduciary, manages to procure that his ill-gotten gains are put into the hands of ostensible third parties, ostensible innocent third parties. Lord, my fourth general observation.
When you say what it's there for, you mean the function it serves?
Yes.
That isn't necessarily the motivation behind it existing.
Lord, the motivation behind it, your Lordship obviously makes a fair point. The motivation behind it is the same motivation as the motivation behind the liability to account. They go together. And it is that a trustee may not, or a fiduciary, may not make a profit from his position without the consent of his beneficiary or principal. If one thinks about the legal policy, it's not obvious why that should go to the beneficiary as opposed to the state or the king, but the law has chosen a result that, as he must be stripped of his profit, has to go somewhere. Why shouldn't it go to the beneficiary who's actually the victim of his wrongdoing? And there is no, if you think about the sort of doctrine, the juridical purpose, I do. Perhaps I will seek to defend my proposition about purpose. Your Lordship's quite right to say perhaps it's properly called function. But the reason for the constructive trust, it's clearly, in my submission, to support the liability to account. The constructive trust wouldn't have been there without the liability to account. How does it support it, I ask forensically? It supports it by allowing the beneficiary of the constructive trust to make proprietary claims, tracing claims against third parties, into whose hands the ill-gotten gains may come.
Or, of course, in the context of insolvency.
I'm so sorry, your Lordship's quite right, and I'm quite slightly surprised I didn't say that. Yes, and to prevent third parties getting the benefit of that money, whether those third parties be people in cahoots with the errant fiduciary or creditors who have no specific claim in respect of the ill-gotten gains. Fourth preliminary observation, this is about the claim against Mr. Stevens. It's important to remember that Mr. Stevens did not receive the hotels or the profits, but he simply made Cambulo available to Mr. Ruhan so that Mr. Ruhan could, ostensibly on the basis that Cambulo had no connection with Mr. Ruhan. It's on that basis that he's liable as a dishonest assistant. The judge would have granted HP2, had it so elected, an account of profits as against Mr. Stevens in respect of the 1.5 million profits that he himself made. And for your Lordship's note, that's at paragraphs 264 to 269 and 342 Roman 2 of the judgment. This is where I actually wrote those paragraphs down, I now realise.
I hadn't really focused on this. I saw the 1.5 million liability. You say he would have ordered Mr. Stevens to account for that money.
Well, yes, perhaps we could look at 342.
Meaning that he didn't, because there was an election to go the other way.
Page 217 of the judgment. Paragraph 342, Roman 2. HP2's claim against Mr. Stevens for, at its election, an account of profits or equitable compensation for dishonest assistance in breach of fiduciary duty succeeds. So your Lordship see, at its election, an account or compensation. So he would have allowed an account of profits had it been elected for.
And if I looked at the order, which I haven't properly, I would find that the election was made in favour of the account of profits.
No, compensation. The election was
in favour of compensation, sorry, yes.
Yes. Lord, the order is at behind divider 6 at page 95, and the relevant paragraph is paragraph 9. It is an order requiring Mr. Stevens to pay equitable compensation. It's behind divider 6 at page 97 of the core bundle. The key paragraphs which I'm appealing from, my learned friends and I are appealing from, paragraphs 9 and 10.
Yes, I follow. So there was an election for compensation.
Now, as your lordship has said, or as we've just discussed, an election was made for an account of profits. That for compensation for loss. That claim for compensation faced a problem. As we've seen, the scheme that Mr. Stevens assisted was a scheme whose only purpose was to allow Mr. Ruhan to enjoy the profits from the hotels. They caused HP2 no loss. It wasn't at HP2's expense. So at first blush, the loss-based claim looked hopeless, just as the conspiracy claim was hopeless. If a conspiracy claim failed, as a matter of common sense and fairness, one would expect the dishonest assistance claim, a loss-based dishonest assistance claim, to fail as well. But the judge came to HP2's rescue by his analysis, which, in my submission, is a highly novel one. Certainly on this side of the court, we've not found any case in which anything like this has ever been attempted before in the authorities. It started by drawing a subtle distinction between Mr. Ruhan's making of the hotel profits for himself on the one hand, and his enjoyment of those profits, what the judge at various points calls his retention and disposal of those profits, on the other. Now, one might think, and in my submission one would be right to think, that where you have made a profit for yourself, that necessarily entails being able to enjoy it. It's kind of part and parcel of the concept of making a profit. It's yours to apply as you see fit. But the judge adopted a distinction between the making and the enjoying. And on the basis of that distinction, he held that Mr. Ruhan had committed a separate and distinct breach of duty when he failed to account for the profits he'd made and used them for his own benefit. He characterised that, as your lordship will be aware, as a breach of the custodial duty that he has as a constructive trustee, although, as I've said, the breach added nothing to Mr. Ruhan's personal liability. And he held that Mr. Stevens had separately and distinctly assisted that breach, and it was open to HP2 on the pleadings to sue for loss for that breach. Now, we've seen from the particulars, there was no actual allegation of this custodial breach, or that it was assisted. But in any event, the judge found that the claimant was entitled to sue. The key point I seek to make to your lordships on this, on my first ground of appeal, is that HP2, the judge found that HP2 was entitled to claim compensation in respect of the separate breach and in respect of the separate assistance without bringing the first breach or the first assistance into account. In other words, when considering the counterfactual position by reference to which the loss was to be assessed, the judge, if I can use this metaphor, started the clock halfway through the wrongdoing. Your lordship will be aware, will recollect from cases like Target. Claimants are often criticised for stopping the clock halfway through the wrongdoing. This is the opposite problem. This was a case where there was an attempt to start the clock halfway through the wrongdoing and to ignore the wrongdoing that had gone before. And it's only on that base that it's possible to say that HP2 can be regarded as having suffered a loss. Now, as I've said, as I've submitted, this analysis, for the purposes of establishing a liability and dishonest assistance, is new. In my respectful submission, it's revolutionary because it completely changes the nature and effect of the rules relating to liability for dishonest assistance. And it does so, as your lordship will appreciate, I say that it does so in a way that's fundamentally inconsistent with novoship. That's my second ground of appeal. As I will explain, in most, if not all, dishonest assistance cases involving misappropriation of property or a fund by a fiduciary, the effect of the judge's analysis is to make the dishonest assistant automatically liable to the principal, not just for the loss suffered by the principal as a result of the misapplication, but for all the profits made by the fiduciary. And in my submission, that is an amazing result. It's the exact opposite of what this court decided in Novaship. And that result is based, as I've said, on the narrowest of distinctions now being drawn between the assisting of the making of a profit and the assisting in the retaining or disposing of a profit. In my submission, just looking at those bare facts, something must have gone wrong. By the first and second grounds of my appeal, I seek to explain why. The third ground of appeal, of course, in relation to compound interest, as your lordships will appreciate, it's based on the fact that there is binding authority from the House of Lords that compound interest is only available in two circumstances, and this case is clearly outside those circumstances. And Westdeutsche Landesbank should not have been swept aside as it was. So if I could now start with ground one of my appeal. The judge was wrong to hold that HP2 could claim equitable compensation for loss on the basis that it was entitled to be put in the position it would have been in had the hotels been acquired and sold by Cambulo and had Mr. Ruhan counted to HP2 for the profit. I should start by the suggestion in HP2 skeleton that it's not open to Mr. Stevens to run this argument. I'll allow my learned friend to develop that point in due course. I don't want to get distracted at this stage. But I would say that the analysis that your lordship see in the relevant part of the judgment came from the judge. This two breaches of duty, two separate breaches of duty, separately assisted, that came from the judge. And it came from the judge right at the end of the trial during, not HP2's, but during Mr. Stevens' closing submissions. Secondly, I note that permission to appeal would have been given by the judge in any event. The judge had real reservations about his decisions. Your lordships will see that from paragraphs 285 and 286 of the judgment. Lord, I don't propose to say any more at this stage.
I don't know if it matters. When you say the judge would have given permission to appeal in any event, what do you mean by that?
Oh, I'm sorry, I should explain. So after the judge had produced his judgment, containing the analysis that we'll be discussing, there was then quite a long lull, and there was a consequentials hearing, perhaps some 6 months later. And at the consequentials hearing, Mr. Stevens' team, didn't include me at that stage, sought to develop the points which are now contained in our skeleton argument. Not all of those points had been developed before the judge. They couldn't have been. And I'm sorry to use this tendentious term, but Mr. Stevens' legal team were ambushed with the analysis on day 12 of the trial, and they had the short adjournment to consider it, and then it was done, then it was passed. It took them some time, and being a newcomer to this case, I can confirm it does take some time to think about what the problems must be, what's going on, how can that be right? And that time was taken, the time between the judgment and the consequentials hearing, for Mr. Stevens' legal team to formulate the arguments, essentially the arguments that are now being run now, plus an extra gloss, for which I was involved in relation to an additional point being run by HB2. So when I say the judge would have given permission to appeal in any event, he says so. I mean, first of all, he said, indicating in his judgment, he was proposing to give permission to appeal, as I believe. 67. But it's certainly in paragraph 67 of the consequentials judgment. Well, that's behind divider 8. That's at paragraph 67, page 237. Perhaps I'll allow you, ask your lordship simply to quickly look at that.
So, the judge did give permission to appeal. When you say in any event,
Well,
you
it's,
mean-
it's 3 lines from the bottom of the page at 237. I was already satisfied that permission to appeal would be granted.
Yes, I see.
But Lord, so this case is rather stronger than Novoship. Novoship was another situation where the arguments that were debated on the appeal were not the same as the arguments that had been debated at first instance.
And of course, in reality, this court not uncommonly allows new arguments to be run, provided that they don't turn on facts which weren't explored at the trial.
Lord, in my submission, yes. So those are my submissions on the on my learned friend's objection. Let me start by making some points clear about what I'm not saying on this appeal. I am not suggesting, I should say we, my learned friends and I, am not suggesting that where a fiduciary such as Mr. Ruhan has improperly made profits, he is not accountable for those profits. I accept that he is accountable. Nor are we suggesting that the fiduciary does not hold those profits on a constructive trust. Indeed, it's a Paragon Category 1 trust. That is to say, it's a real trust, creating real rights and obligations, including what might be called a custodial duty. So we accept that Mr. Ruhan, through Cambulo, held the hotel profits on a constructive trust. No part of this appeal is based on the proposition that a breach of this custodial duty, for which in the course of this appeal I shall call a custodial breach, is not juridically capable of being pleaded as a cause of action in its own right. Although I do say it's difficult to see how in fact it could be pleaded without also pleading Mr. Ruhan's underlying breach of duty as the director of HB2, which in this appeal I shall call a fiduciary breach. So there's the original fiduciary breach, and then there's the custodial breach. The gist of my appeal, please tell me if I'm going too fast. The gist of my appeal is that although there is a formal, if there's capable of being a formal separation of the two duties, the original fiduciary duty and the custodial duty, the custodial breach is so inextricably bound up in the fiduciary breach and in the liability to account immediately following from that breach that it cannot be treated as what might be called an independent or distinct breach. So the distinction I draw is between separate and distinct, for want of a better phrase. With the result that when considering what losses have been caused by the custodial breach, it's not possible conveniently to ignore the fiduciary breach that preceded it. Let me start with first principles. First of all, there's the classic exposition of the fiduciary's duty to be found in Lord Justice Millett's judgment in Bristol and West. I know that your lordships will have it well in mind, but shall we have a quick look at it? It's in the authorities bundle 2, behind divider 18. And it's the page 727. Where I refer to pages when I'm discussing cases, I generally refer to the bundle page references. So that may be irritating when it comes to your lordships, referring to pages of judgments in your final judgment. But it's the famous passage at the top of page 18 of the report, page 727 of the bundle. This leaves those duties which are special to fiduciaries and which attract those remedies which are peculiar to the equitable jurisdiction and are primarily restitutionary and restorative rather than compensatory. Well, we'll be talking about that later. A fiduciary is someone who's undertaken to act for or on behalf of another in a particular matter in circumstances which give rise to a relationship of trust and confidence. The principal is entitled to the single-minded loyalty of his fiduciary, and here's a sentence I place great emphasis on. This core liability has several facets. A fiduciary must act in good faith. He must not make a profit out of his trust. He must not place himself in a position where his duty and his interest may conflict. He may not act for his own benefit or for the benefit of a third person without the informed consent of his principal. This is not intended to be an exhaustive list, but it is sufficient to indicate the nature of fiduciary obligations. They are the defining characteristics of the fiduciary. And then there's a reference to Dr. Finn's famous book. Lord, your Lordship will understand where I'm going. Lord Wolfe, Master of the Rolls, made a similar point in the Court of Appeal in Attorney General and Blake. I don't know if it's referred to in my skeleton. I don't know if your Lordship will would need to look at it, but for your Lordship's note, it's in the same. Well, let's look at it quickly. It's behind divider 16. It's page 677 of the bundle. And rather than reading out loud, could I invite your Lordships to read the paragraph starting at letter B? There is more than one category. Does your Lordship see that?
Sorry.
It's page 677 of the bundle.
Yep.
It's the paragraph letters B and C on the side.
And this is a judgment of the court, isn't it?
Oh, your
Clearly.
Lordships, I stand corrected. I'm so sorry.
Clearly Lord Millet, as he was later to be.
It is the judgment of the court. You're quite right. I'm so sorry. So this core fiduciary obligation, duty, has several facets. But in my submission, it wouldn't be right simply to regard them, although we often talk about them as if they are, because it's easier to do that. It wouldn't be right to regard them as somehow freestanding duties. And perhaps I could show that by reference to Professor Mitchell's book. If I could invite your Lordships to go to bundle 9 of the authorities bundle. You could put bundle 2 away for the time being. It's behind divider 69 at page 3192. This is Professor Mitchell talking about Lord Justice Millet's judgment in Bristol and West. He says in the marked passage, in Bristol and West and Mothew, Lord Justice Millet said that a person is not subject to a fiduciary obligation because he is a fiduciary. It is because he is subject to them that he is a fiduciary. He described fiduciary obligations as a set of obligations whose core is the duty of single-minded loyalty. However, he did not mean by this that there are several fiduciary duties, the most important of which is a duty to be loyal. He meant that there is one fiduciary duty of loyalty with different facets. These reduce to 2 rules. A fiduciary must subordinate his personal interest to his principal's interest, and he must not serve 2 principals whose interests conflict. Lord Justice Millet also affirmed that the existence of a fiduciary relationship does not mean that every duty owed by a fiduciary to the beneficiary is a fiduciary duty. So that's my first point, first brick in, first point that I should make. It's the second submission I would make is that although it's not how modern lawyers talk or think, it's worth remembering that in their fundamental nature, fiduciary duties are essentially proscriptive in nature, not prescriptive.
I don't know whether this will prove to matter in this case. Obviously, in Australia, it's been said very specifically that fiduciary duties are exclusively proscriptive. I'm not sure that that necessarily fits every English authority. For example, item services and fasihi, which looks rather prescriptive.
Well, my Lord, perhaps I can scuttle in an ignominious way away from your Lordship's question by simply saying, for the purposes of a claim in relation to unauthorised profits, there are two ways of looking at that claim. You could, if you want to be nominalistic about it, look at it as a claim for profits because there's been a breach of a duty to seek consent. Another way of looking at it, though, is that he's made a profit without consent. That means he's automatically liable to account for them. Your Lordship will be familiar with this argument because, as I understand it, it's an argument that you yourself ran in a case called Murad many years ago. And the court didn't find it necessary to decide it. I'm going to take you there in a few minutes. But for the purposes of this analysis, I would respectfully submit that it would be right to say that in this context, it's correct to... I should make it clear that my analysis doesn't depend upon this proposition.
Yes.
But it is an important factor because it sheds light on the nature of the interconnection between the duties which the court holds fiduciaries are subject and the remedies arising and the practical results of those remedies which arise from breaches. I was going to take you back to Attorney General and Blake, but perhaps it's not necessary to do so. For your Lordship's notes, it's at page 678 of the bundle. Equity tells the fiduciary what he must not do. It does not tell him what he ought to do. But I see that your Lordship's more than alive to this line of reasoning. Now, there are positive obligations, such as an obligation to account for profits. They arise only upon a breach of the fundamental duty of loyalty, and they arise as remedies rather than standalone duties. Well, that's a point made by Miss Justice Blair in a case called Forster, A.P. Fondon and Bank of New York Mellon. Perhaps we should look at it very quickly. It's bundle 6 of the authorities bundle, behind divider 38. It's not necessary to talk about the facts. It's at page 2063. This was an attempt by the claimant to say that in addition to a number of contractual duties, he could also rely on the fact that what the defendant had done, I think it was in a complicated syndication or something, also constituted breach of fiduciary duties. And then at paragraph 184, Miss Justice Blair said, as it has been put, equity is proscriptive, not prescriptive. It tells the fiduciary what he must do. It does not tell him what he ought to do. There's the Blake passage. BNYM submits that a fiduciary duty to act in the client's best interests means that the fiduciary must avoid conflicts and must not make a secret profit. Positive obligations are engaged only where the duty is breached. Thus, a fiduciary in a position of conflict must disclose it and seek consent from his principal, and one who makes a secret profit must give an account and disgorge it. But, it says, these positive obligations arise as remedies rather than standalone duties. I agree with this analysis. Yeah. But, Lord, as I've already adverted, perhaps we could go to bundle 4 of the authorities. I should take you to the Murad case. It's bundle 4 behind divider 32. It's at page 1333 at paragraph 49. This is, I think it's Lady Justice Arden's judgment. It's a joint venture in relation to which the joint venture failed to disclose and in fact gave misleading information about critical aspects. And in paragraph 49, her ladyship said, there has been some debate as to whether Mr. Al-Sarraj was liable for breach of fiduciary duty because he was under a duty to disclose information which he failed to disclose, or whether he made a secret profit for which, in the absence of disclosure and the consent of the Murads, he's liable to account on the basis of that such liability is an incident of the fiduciary relationship rather than a breach of duty. The judge's judgment suggests the former. Respondents rely on the latter because that leads them directly to the Regal case. That's Regal and Gulliver. For my own part, for the purposes simply of the question on this appeal, I don't think it matters which way the appellant's liability is analysed. But, my Lord, the reason why I take you to these propositions, one could choose hundreds, of course, is to seek to urge upon your lordships the very intricate, inextricable, I'll be using the word inextricable a lot in this part of my appeal, relationship between the original fiduciary breach and its consequences, and its equitable consequences in terms of liability to account for profits, constructive trust supporting that liability to account, and so on. So the question that was debated in Murad doesn't matter for the purposes of this appeal, doesn't need to be decided for the purposes of this appeal either. Both ways of looking at it are good enough. The point is that there is an interdependence, an inextricable interconnection between the original fiduciary duty breached and the consequent liability to account and the constructive trust that supports it.
What it's worth at the moment, I'm drawn by the argument that I evidently was advancing in that case. The second way of putting it seems more attractive at the moment.
Oh, good. Yeah. One can see why. I mean, there's 150 years of authority leading up to probably the Second World War, where that was just the traditional way of looking at things, and then lawyers with a sort of different background became involved. And I hope I'm not oversimplifying the historical development. Lord, if I could just talk about your lordship asked a question about the constructive trust, and of course I'm very anxious to persuade the court that it's essentially supportive of the liability to account. Its purpose, as I've already tried to explain, its purpose is to ensure that the personal liability to account, first of all, prevails against creditors, and secondly, can be asserted against third parties whom the errant fiduciary has recruited to his evil ends. By which I mean people who aren't equity's darling, of course. It's driven by the same concern, the same equitable objective, which is to ensure that the errant fiduciary does not retain any benefit from his breach or from his abuse of his position so as to obtain a profit. And one sees that from a case called United Pan Europe against Deutsche Bank. Well, that's in bundle 3, behind divider 23. And if I could pick it up at page 1050. This was a case where it was suggested that a sale by one bank of the business should be set aside because the person selling the business owed fiduciary duties to the claimant. It's rather curious. It was the third-party sale of the business, but the claimant was claimed that the vendor owed fiduciary duties and also had confidential information which they had used for the purposes of the sale. And perhaps I could ask your lordships to pick it up at page 1050 at paragraphs 44. Well, no, perhaps let me save some time. Picking it up at 46. For UPC, it's contended that the judge adopted an erroneous approach. First, it's not a requirement for the imposition of a proprietary remedy that the profit should have been obtained for the fiduciary by virtue of his position. Second, the purpose of imposing a proprietary remedy is not to compensate the beneficiary, but to ensure that the fiduciary does not profit from his breach of duty. And the judge says, and the judge being for this purpose Lord Justice Morritt, in paragraph 47, he says, for my part, I think there is substance in both submissions. So there we have Lord Justice Morritt agreeing that the proprietary remedy, the constructive trust remedy, is not to compensate the beneficiary, which is of course what its function, the function it's performing in the judge's analysis today, but to ensure that the fiduciary does not profit from his breach of duty, which is the function that I say it performs. And of course, in that sense, the constructive trust can be said, accurately be said, to be remedial in nature. And when I say that, I'm not suggesting it's not an institutional trust, because of course it is. This trust does not depend on the exercise of the court's discretion.
Again, I'm not sure any of this matters at the end of this case. You're obviously right to step away from saying it's purely remedial, since we don't recognise remedial constructive trusts. But in terms of saying that the imposition of the proprietary consequence is to ensure that the fiduciary doesn't profit. I mean, you don't need anything proprietary to achieve that, do you?
Well, you do. There are different ways of looking at it, I suppose. You could say that when someone's creditor manages to grab some of the profit, in a sense, the debtor is being benefited because his debt is going down. You could also say, and in fact it will often be true to say, that where if someone obtains some ill-gotten gains and they find their way into the hands of a third party, and that third party isn't a bona fide purchaser for value without notice, 9 times out of 10 it'll be because that third party is either a vehicle for the interests of the original wrongdoer or is in some other way in cahoots with him.
Yes, I see.
And that's why we have these elaborate rules arising from the masterful analysis in Barnes and Addy of Lord Selborne in Barnes and Addy. Lord, I don't say it's a remedial constructive, obviously. Perhaps a better way of describing it would be secondary to constructive trust. But for the purposes of my analysis, the point is that it is intrinsically connected to. I'm going to run out of adjectives, or are they adverbs? I don't know which. At some point, but your lordship sees what I'm trying to the point that I'm trying to make here. One can't properly understand what's going on with the constructive trust or with the liability to account with understanding the underlying fiduciary obligation to which it is entirely connected. Next submission. Actually, this is my next submission. These secondary or remedial obligations are inextricably linked to the original breach. It's a point that Professor Birss himself makes. Again, if I could go back to his book, which is in, I think it's in bundle 8. I am sorry for having to jump around from bundle to bundle. There is no other way of doing it, however. It's tab 58. At page, hilariously, 3037. Page 39 of the I should tell your lordships, this is Peter Burke's article, Content of Fiduciary Obligation, published in 2002. And there's a passage there at the top of the page headed Primary and Secondary Obligation. Perhaps I could invite your lordships to read that passage. It won't come as any surprise to you.
Yes. So the whole section down to Part 2 altruism.
Yes, the marked section.
Sorry, what page did you say?
Page 3037, my lord.
Thank you very much.
Your Lordships, I'm going too fast. Your Lordships will note the reference in the first paragraph to the example of contracts. Your Lordships will also bear in mind, it's in our skeleton argument, but we needn't look at it, the decision of Lord Diplock in Photo Productions and Securicore, where he analyses claims, orders for damages or claims for damages for breach of a contract as a secondary obligation arising from the breach of the primary obligation. The important point is that the secondary obligation cannot sensibly be regarded as a freestanding obligation, which is entirely distinct from the original breach, the primary breach. And I emphasize the word distinct. Two words which I'll refer to in a number of occasions, the difference between the word separate and the word distinct. Now, against that background, could I now go to the judge's analysis? His judgment is in the core bundle by 7. I can pick it up at page 194. I invite the court. So at the end of paragraph 278, well, perhaps I invite your Lordships to read paragraphs 278 through to 281.
We'll do that.
So you would say, would you, that just as in contract, you can't get damages for breach of a secondary obligation to pay damages, so in equity, you can't get compensation for, and then how would you complete that sentence?
The analysis is different for contract and equity. In contract, your Lordship is bearing in mind the Law Debenture Trust and Euro-Caspian, the decision of the Court of Appeal which said you can't have liability for interfering in secondary obligations. You can't have a liability, civil liability for procuring breach of a secondary obligation. And the analysis is more complicated in equity because of the existence not of a constructive trust which is real, and I accept that it's an institutional trust. But what I say is that although the breach of such a constructive trust could be said to be separate in the sense that one could plead juridically, a cause of action for breach of the custodial duty, which involves different facts pleaded from the cause of action you would plead a breach for the underlying fiduciary duty which gave rise to the constructive trust. Nonetheless, the connection between the constructive trust which is breached and the fiduciary obligation which is breached and their breaches is so intimate that they cannot be regarded as distinct. And the point I'm seeking to bring home to your Lordships now, if I may use that expression, is what I seek to do is, it is not right to say that there is a general rule, as His Lordship does in paragraph 283. There is a general rule that where you've got separate causes of action, you can sue on them separately, and you can cherry pick, you can pick and choose, and you can sue on the ones that benefit you, and you can ignore the ones that are against you. That is not a general rule. What's required is not that there is a formally separate cause of action. What's required is that the causes of action are distinct. And that is a more searching test. That involves a different inquiry, merely from the nominalistic content, the formal questions to whether there are two separate causes of action.
And as a matter of language, the distinction between separate and distinct might be thought to be a difficult one.
Well, my Lord, a number of things I could say in response to your Lordship's question. Whether, at the end of the day, what this debate is about, it's about the counterfactual that the court adopts when determining whether a particular breach has caused loss and is therefore compensable by way of equitable compensation.
Yes.
And in determining that question, there are rules which make it clear, or from which it can be seen, let me put it that way, I don't want to put my case too high, from which it can be seen that you are not allowed to adopt a counterfactual which excludes prior wrongdoing that causes a profit in circumstances where the prior breach is sufficiently closely connected to the subsequent breach. Whether you, and I'm using the word distinct as an attempt to capture that idea, it's not enough that there is a formally separate cause of action that you can plead that allows you to ignore all the other, all benefits derived from other causes of action. It's that sometimes the connection between them is so distinct that you're not allowed to make a claim on one without taking account of the other. Often it's considered as a matter of giving credit for earlier benefits, but that's not. I mean, juridically, what the court is doing is it's working out what the counterfactual is, by reference to which the ultimate position that the party was in is compared, such that the court can then assess what the proper assessment of the claimant's loss is. And as I say, that depends not whether you can do that or not, depends not on whether the breach is separate, formally separate, pleadable as a separate cause of action. It depends on whether the breaches are distinct. If the breaches are distinct, then you can cherry pick. But if the breaches properly understood are not distinct, then you can't. And the reason why you can't is because it's unjust, to use the phrase of Mr. Justice Brightman in Bartlett, which we're going to come to, or to use another phrase in the next case, it's unfair, unjust, and unreasonable to do that.
The formula you're using sounds a bit like the language of equitable set-off. Has that got anything to do with
equitable
set-off? Just thinking of the way you put it, it just rang those echoes. I don't know if that's
I wish I'd thought of that before I set foot in court this morning, Lord. May I go away and think about that? I could see exactly why. I could see that there may be parallels that are worth looking at, and may I go away and think about that? Thank you. But I'm afraid I'm not in a position to say yes right now. It sounds helpful, but I need to think about it some more. So that's where I'm going. Let's see how the rule is summarised by in the textbooks. Perhaps I could ask your lordships to go to Underhill, which is in bundle 9 behind divider 76. and it's at page 3241. This is the 2022 edition of Underhill. And rather than read out the words, perhaps I could invite your lordships to read pages 3241 through to 3243, the entire passage. So your lordships will see the emphasis placed on the use that's made of the concept of there being a distinct breach of trust. And that's the concept I'm trying to get at here, and that's the nomenclature I shall be using. The cases don't often use it, but it's a helpful form of vocabulary in my submission. If we could look now at Bartlett and Barclays Bank, a case which it's in bundle 1 behind divider 8. I know that everyone in court will have read this more than once. Page, the report starts at page 232 of the authorities bundle.
Sorry, which page?
232, behind divider 8.
Yes, sorry. Yes.
Facts will be well known to you. The trustee was a bank that had failed properly to oversee the actions of a company in which the trust held the vast majority of the shares. The directors from, I think, about 1960 had adopted a policy of investing, instead of just holding property for its value, they'd embarked on a policy of investing in speculative projects, speculative developments. The company invested in 2 speculative developments that were relevant for the purposes of this case, one of which was a project in Guildford in 1961, which produced a thumping profit. And the other was called the Old Bailey project, was a project in the early 1970s that proved disastrous, probably, I imagine, because of the 1974 property crash. Now, the proposition for which this case is best known, although there are a number, is of course that a trustee in that situation is under a duty actively to oversee the operation of the company and to ask proper questions and so on. So I should make it clear that the breach of trust that was alleged was effectively a want of care and skill. But it's also worth noting that the underlying actions causing loss were actions involving applications of company money. So money was going out of the company and therefore going out, in a sense, going out of the trust. But I'm not saying that this wasn't a claim for misappropriation by trustees. But there were analogies, and indeed, in his consequential judgment, Mr. Justice Brightman did talk about restoring the trust fund. Anyway, the trustees were held to have breached its duty of care and skill, and the judge was called upon to determine the loss for which the trustees were liable to compensate the trust, to restore it to the position in which it should have been. And the question arose whether the trustees could set off the earlier gain from the 1961 Guildford project from the major loss from the early 1970s Old Bailey project. The trustee allowed both speculative ventures to proceed, so in that sense there were clearly separate breaches of trust which could have been separately pleaded and separately proved. So there was formal separation between the breaches. And unsurprisingly in that situation, the claimants, the plaintiffs, sought to apply the rule which was adopted by Mr. Justice Foxton in our case, that it's open to a plaintiff, to a claimant, to cherry pick. Mr. Justice Brightman rejected that approach. As I say, Mr. Justice Foxton should have rejected it in this case. He held that the trustee was entitled to set off the gain from the 1961 breach against the loss in the early 1970s breach. And if I could pick it up at page 532 of the report, which is at page 249 of the bundle. Perhaps I simply ask you just a bit of background. Ask your lordships to read the paragraph beginning at letter B on page 249 of the bundle.
Yeah.
The way that the judge puts the fact there leads to this inference, I would submit, not critical for my submissions, but it's worth drawing attention to. Had the trustees not been overseeing the directors of the company, but had they been engaging in the speculative development themselves, this could have been seen to be a misappropriation case. There is a basis for thinking that had it been viewed as such, the result would have been the same. And then,
when you say misappropriation,
unauthorised
you mean
payment.
because outside the powers?
Yes.
In another sense, it's a want of care case.
Absolutely. Not misappropriation in the sense of stealing it for yourself. Misappropriation in the sense of making an ultra vires payment or making a payment out of capital by a director of a company. That sort of misappropriation, where the director acts in perfect good faith, but it's actually beyond his powers. He shouldn't have done it. Lord, if we could then pick up, see how the judge decided this counterfactual question, as I would characterise it. It's at page 255 of the bundle. Page 538 of the report. The judge says, there remains this defence, which I take from paragraph 26. Your lordships will see, in about 1963, BTL purchased a site at Woodbridge Road, Guildford, pursuant to the policy pleaded in paragraph 19 hereof, So it was the same policy by the directors, and resold the same for £350,000 in 1973. The net profit resulting from such sale was £271,000. If which is denied, the defendant is liable for breach of trust, whether as alleged in the amended statement of claim or otherwise. The defendant claims credit for such sum of £271,000 or other sum found to be gained in taking any accounts and inquiries. So there was a clear attempt to say, I'm allowed to claim credit for this earlier breach because it was beneficial and the breaches were connected. And then his lordship said, the general rule as stated in all the textbooks, with some reservations, is that where a trustee is liable in respect of distinct breaches of trust, one of which has resulted in a loss and the other in a gain, he is not entitled to set off the gain against the loss unless they arise in the same transaction. And then there's a reference to a number of authorities. The relevant cases are, however, not altogether easy to reconcile. All are centenarians, and none is quite like the present. The Guildford development stemmed from exactly the same policy, and to a lesser degree because it proceeded less far, exemplified by the same folly as the Old Bailey project. Part of the profit was in fact used to finance the Old Bailey disaster. By sheer luck, the gamble paid off handsomely on capital account. I think it would be unjust to deprive the bank of this element of salvage in the course of assessing the cost of the shipwreck. My order will therefore reflect the bank's right to an appropriate set-off. So what his lordship was doing there was saying, I'm going to make, in making a principled assessment of loss, I'm not simply going to look at the loss flowing directly from the breach that's been pleaded. I think it's appropriate to take into account an earlier breach because of the connection, the benefit from an earlier breach, because of the close connection between that earlier breach and the first breach. And what were the connections? First of all, same policy adopted by the directors. So same error committed by the trustees. And secondly, part of the profit from the first venture was actually lost as a result of the second venture. And given those connections, he held that it would be unjust to deprive the trustee of the profit in the course of assessing the loss. Lord, in my submission, this is an authority on how equity approaches the assessment of loss when determining the proper measure of equitable compensation.
Mr. Justice Brightman is obviously held in high regard. It's hard to extract from that paragraph what the dividing line is.
Lord, that's right. But what it does do, however, is it demonstrates there is a dividing line. Yes. It is wrong, in my submission, to do what, in my submission, Miss Justice Foxton did in this case, just to say there's a general rule. If you can plead a separate cause of action, you can cherry pick and you can ignore in claiming loss, you can ignore benefits derived from other breaches. That is Bartlett, in my submission, is an authority which shows that that's not right, if your lordships choose to follow it. Lord, secondly, there is one other proposition that can be derived from it, which is that it's an illustration of the kind of things the court considers when determining whether to regard a cause of action as merely separate, or as I would have it, as separate but not distinct. And what he does is he looks at the relationship between the breaches, and as a matter of practical fairness and common sense, he decides whether it would be appropriate for the loss to be calculated without reference to the gain. So there is an obvious analogy between the facts of that case and this case. The initial breach in 1961, which resulted in a profit being made for the trust, could be compared to Mr. Ruhan's original fiduciary breach, by which he makes a profit for himself, which he holds on trust for HB2. Then the subsequent breach in the early 1970s, making a loss from the trust, could be compared to the custodial breach by which Mr. Ruhan used that very profit. And in a way, our case is stronger in that in this case, the whole of the loss represents the whole of the profit initially made. What they're complaining about is that you made a profit that I was entitled to claim, and then you spent it. In Bartlett, it was only part of the profit that represented some of the loss paid away. But at least in relation to that part, there was, the profit came in and then it went out again as a result of the second breach. So there is, in my submission, an obvious analogy. For present purposes, what I submit is that the connection, the judge found that the connection was such that as a matter of justice, it's appropriate, it would be inappropriate to ignore the original breach and therefore ignore the original profit. It's expressed in terms of credits against debits, but in my submission what the court is actually doing is determining the counterfactual by reference to which the loss ought to be measured. The second case I'd like to rely on in this line is a case called Holbert and Evans. It's in the bundle. It's in bundle 4, behind divider 30. It's a decision of His Honour Judge Richard Seymour. Holbert and Evans, page 1249. I'm so sorry, I think my Lord Justice Birss is looking at the, using the computer. I should give you the...
Not to worry, it's all working fine. Right. You're giving me all I need, Mr.
Wilson. The facts of this case were as follows. Evans and Edwards, the defendants, were trustees of a number of trusts. There may have been 3. The trusts owned some land, family trusts. The trusts owned some land, and the sale attracted capital gains tax liability of £230,000. Instead of paying the CGT, the trustees made advances to the beneficiaries of the proceeds of sale, leaving them with insufficient funds to pay the tax. The result was that the CGT was paid late, and with a consequence that interest and penalties became payable by the trust. The trustees admitted that they were liable for the interest and penalties, and they paid most of them out of their own money. But some of them were paid out of trust funds. That was the issue on which the matter came before this court, because the claimants said, "Well, hold on, you've forced the trust to incur a liability to pay CGT interest and penalties, and you've used trust funds to discharge that liability. You should restore the trust fund by paying in the necessary amount, so it all comes out of your pocket. The trust shouldn't pay a penny." The trustees' argument was no. The amount that we're talking about, the amount that you say was misapplied, was actually represented interest that was earned by the trust as a result of the fact that it made late payment of the CGT. So if one chose to look at the case this way, it would be possible to analyse it as follows. There was a breach of trust in failing to pay CGT on time. That breach caused a profit for the trust in the form of interest on such funds as it had left, which were on deposit account. There was then a second breach where the trustees used that interest to defray part of the penalty and interest liabilities owed by the trust. And the question, technically, that's a breach, because what's being paid is a liability to which the trust should never have been exposed in the first place. So there's a second breach of trust but it was a breach of trust involving misapplication of profits arising from the first breach of trust. I'm putting that in a way that suits my case. It's fair to say that, that the court doesn't analyse it in precisely that way. But your lordship will see that the problem, there is an obvious analogy between that situation and this one. And in these circumstances, in my submission, it's important to know that the judge in my submission rightly held for the defendant trustees, and he denied the claimants any relief in respect of what they'd done. So if I could pick it up.
Is there any particular passage
Yes.
from which we can see the judge's reasoning?
Well, if I could, I was going to take you to rather more than just a particular passage.
No, do then.
Well,
Sorry, yes. I thought you were moving on to another case.
No, I'm paragraph 32, my lord, which is at page 1257. First half of the paragraph, it simply makes clear, it's apparent that in deciding what contribution it was appropriate to be made on behalf of Mr. Evans and Mr. Edwards, they're the trustees, to each of the trust funds, in respect of their admitted breach of trust in failing to pay at the appropriate time CGT, and thereby incurring a liability on the part of themselves as trustees to pay interest and penalties, which liability was met in part by recourse to the monies held on trust. Account has been taken in favour of Mr. Evans and Edwards of the amounts of interest earned by monies within the funds held on deposit, which would not have been made available, which would not have been available to earn interest if they'd been paid when they should have as CGT. The main outstanding issue in this action is whether it was appropriate for the interest earned to be taken into account in this way. So that was the issue. We move on to page 1260. Your lordships will see in paragraph 40, the defendants relied on Bartlett. Perhaps I'd invite your lordships to read, just quickly skim that. And your lordship will see that the response of counsel for the claimants on paragraph 41, Mr. Platford emphasised a reference in the passage quoted in the preceding paragraph to a policy and to the use of trust funds to seek to earn profits. He submitted that in the present case there was no evidence of any policy on the part of Mr. Evans and Mr. Edwards, for example, to seek to earn more for the trust by investing money than would have been paid as interest on unpaid CGT. Moreover, he submitted no trust monies were used by Mr. Evans and Edwards to seek to earn profits. And the judge responded, both of these submissions seem to me difficult. Lord, stopping here, that submission may have been difficult on the facts of that case. It's not difficult on the facts of my case. On the facts of this case, the whole purpose of the scheme was to allow Mr. Ruhan to have the profits for himself. In fact, the entire intellectual structure justifying the result in this case depends upon drawing a distinction between the making of the profits and the enjoyment of them. But if anything could be called one policy, that is an example of one policy of the sort that Mr. Justice Brightman was considering in Bartlett. And then if we move on to paragraph 42, there's the learned judge discusses Bartlett. He then says the decision of Mr. Justice Brightman in Bartlett is a convenient prelude to a consideration of the decision of the House of Lords in Target Holdings at Redfern, upon which Mr. Patton relied heavily. And then your lordship will see a summary of Target. If I could invite you just to skim paragraph 42 and 43, see how the arguments are put. Those passages are, of course, relevant to my learned friend's argument on substitutive damages, substitutive compensation.
I do suspect that if we need to consider target, we should look at
Very
target
well.
separately.
I see. My Lord, then perhaps we could move on then to page 1265, paragraph 46, where the learned judge says, Mr. Platford urged upon me that the general rule in the case of breach of trust is that the trust fund is to be restored to what ought to have been there at the date of the breach. His submissions took no account of the observations of Lord Brown-Wilkinson at the end of the passage quoted as to how one should approach the assessment of equitable compensation in a case such as the present, in fact is, namely in which all relevant trusts have come to an end. I reject his submission that I should seek to reconstitute any of the trust funds in the present case, rather than simply consider, in the case of each of Sharon, Robin and Simon, those would be the three beneficiaries, whether they have suffered any loss in the events which have happened, and if so, how much, with a view to awarding to any of them who has suffered a loss, equitable compensation intended to eliminate that loss. And then, my Lord, if one goes forward to page 1268 in paragraph 52, in his oral closings, Mr. Platford did seek to face up to the implications of the decision in Target Holdings. He submitted that the decision was distinguishable from the principles applicable in the present case because of the factual differences between the two cases. The first suggested ground of distinction seemed to be that in Target, money had been paid away in breach of trust, whereas in this case there was no complaint that money had been paid away. Rather, the effect of the breaches of trust complained of was to create liabilities which could and should have been avoided. That analysis seemed to ignore the fact that the liabilities incurred were in fact those of Mr. Evans and Mr. Edwards. The real question, in my judgment, to what extent it was open to Mr. Evans and Mr. Edwards to say that they were in practice entitled to utilise monies earned as interest on sums held on deposit for the various trust funds to meet their own liabilities in reliance on the fact that the interest could not have been earned if the liabilities to pay CGT had been performed when they should have been, and Mr. Evans and Mr. Edwards had reimbursed themselves as they were entitled to from the assets of the trust fund in relation to the CGT, which they paid. Technically, the utilisation of the trust funds to meet expenses which were not proper for the trust to meet, namely the liability to pay interest and penalties consequent upon another breach of trust, namely failing when due CGT payable in respect of the trust fund, was itself a breach of trust. However, it was a breach of trust without practical consequences if Mr. Evans and Mr. Edwards were entitled to have the interest earned taken into account in the assessment of equitable compensation in respect of both types of breach. So what the learned judge is saying there is absolutely what I'm submitting in this appeal, namely that in circumstances where you have a second breach, which is a misapplication, it's a custodial breach, the nature of the breach being to take money out of the trust, which prima facie seems wrong, but in circumstances where the money is only there in the first place because of an earlier breach, in the very breach which the claimants are relying on as demonstrating why the later breach is wrongful, namely you're paying a liability to which the trust should not be subject. In that situation, the connection between the two breaches is so close that it would not be right to look at one on its own without having regard to the other. It would not be right to adopt a counterfactual for the second breach which ignores the benefits derived from the first breach. And then, Lord, the conclusion, I think, is well summarised at page 1217. I was reminded by both Mr. Platford and Mr. Patton that in Target, in the Court of Appeal, Lord Justice Peter Gibson, and your Lordships will recall he was the judge who was upheld in the House of Lords, had expressed the view that the elastic rules of equity are sufficiently flexible to require a beneficiary who, subsequent to the loss, receives a benefit from the trustee's actions to give credit for that benefit. Mr. Platford's submissions in relation to the issue of equitable compensation seem to me to be an attempt to insist on the rigid application of inflexible rules to produce a conclusion that beneficiaries who were in fact no worse off at the conclusion of the administration of their respective trust funds than they would have been had there been no breaches of trust were entitled to further payment from their trustees. The principles applicable to the assessment of equitable compensation in this case, I am satisfied, are those expounded in the speech of Lord Brown-Wilkinson in Target in the passages which I quoted earlier. Those principles are binding upon me. The particular principles which are relevant are that equitable compensation falls to be assessed, as at the date of the trial, in the light of all the information then available as to whether the relevant trust fund, or if by the date of the trial the trust has come to an end, the beneficiary, has actually sustained a loss as a result of the breach of trust, and if so, the amount of such loss. In making that assessment, it is appropriate in my judgment, in this case, as Justice Brightman considered that it was in Bartlett, to look at all relevant matters in the round. I reject the suggestion that the broad principles set out by Lord Brown-Wilkinson are only applicable to the particular type of breach of trust which consists in the payment away of monies from a trust fund. I also reject the suggestion that the proper application of those principles confines attention to what happens after the breach of trust, in respect of which the need to assess equitable compensation arises. The scope of the inquiry is unfettered. It is an inquiry simply into the issue whether, as matters have turned out, the trust fund or the beneficiary is worse off as a result of the breach of trust than he or she would have been had it not occurred. In the present case, as I've demonstrated, and it was not disputed, save by the contention that some artificial limitation had to be imposed upon the factors which it was relevant to consider, each of Sharon, Robin and Simon has turned out, in the light of the payments made on behalf of Mr. Evans and Mr. Edwards, to have received more from their respective trust funds than they would have but for the breaches of trust which are omitted. Only a seriously distorted view of what was fair, just or equitable could lead, in my judgment, to the conclusion that in assessing compensation for a breach of trust, which consisted in failing to pay sums properly due as CGT when due, by reason of which a liability to pay interest and penalties was incurred, which were partly met, technically infer the breach of trust, by sums earned as interest on the monies which ought to have been paid as CGT, it was not relevant to take into account the fact that but for the failure to pay CGT when the due interest utilised in part payment of interest and penalties could never have been earned. The claim of each of the claimants for equitable compensation in respect of the admitted breaches of trust therefore fails. Lord, lots of words in long sentences, scarily long sentences, but your lordships will already have the burden of my submission. The subsequent payment, use of trust funds to pay penalties and interest due to the revenue, which should not have been due and were only due because of an earlier breach of trust, in circumstances where that earlier breach of trust generated the very profits which were used to make that payment, in those circumstances the judge decided it would be wrong to do anything other than look at the matter in the round. In other words, to include the earlier breach and its consequences in deciding whether at the end of the day the trust was worse off, or the beneficiaries, I should say, were worse off. That's actually a very long sentence too. And in forming that judgment, I do advert your lordships to the fact, first of all, that he relied upon Lord Justice Peter Gibson's reference to the elastic rules of equity being flexible to do the right thing, if I can put it that way, at the beginning of paragraph 56. And secondly, I advert your lordships to his notion of only a seriously distorted view of what's fair, just, or equitable. Full stop. I don't want to plead, I'm not seeking to suggest to your lordships that equitable compensation, because it's equitable, it means the court can do what it like. The award of equitable compensation should be governed by principles, very clear principles. But in my submission, there is a clear principle at work here, although perhaps it hasn't been clearly articulated. And that clear principle is in circumstances where there are intimately connected breaches, one giving rise to a benefit and one giving rise to a loss. It would not be, and the question is whether an award of equitable compensation should be made in respect of the loss, there are circumstances where the connection is such that the first breach cannot be regarded as distinct, with the consequence that the assessment of loss includes the benefit which was generated by the first breach. I haven't put that very well, but I think Your Lordship, I hope Your Lordship see how I'm putting my case. Your Lordships will appreciate that in my submission, a similar approach should be adopted in this case. Given the inextricable connection between the original fiduciary breach, the liability account arising from that breach, or perhaps within that breach, and the constructive trust arising at the same time and in the same way and for the same purpose. Given the connection between that and the custodial breach, the breach of the constructive trust itself, on a claim against Mr. Ruhan for equitable compensation for his custodial breach, as a matter of justice, fairness, and reasonableness, it would not be right to regard those two breaches as distinct, and therefore losses cannot be assessed without bringing his original breach into account when arriving at the counterfactual position which is used in order to assess loss. Now, of course, HP2 elected not to claim compensation for that first breach. It elected to claim an account of Mr. Ruhan's profits from the first breach. It couldn't claim compensation from the original breach because of that election. This analysis is relevant to the claim for equitable compensation against Mr. Stevens. But the way that HP2 has framed its claim against Mr. Ruhan, in my submission, brings out 2 points that should not be overlooked. First of all, the possibility of making a custodial breach claim doesn't affect the ultimate measure of Mr. Ruhan's liability. He is liable to pay over all the profits he made from the original fiduciary breach, whether he still has those profits or not. That is an intrinsic part of the essential operation of his fiduciary duty, his overriding fiduciary duty. A fiduciary cannot be permitted to make an unauthorized profit. It must be paid over to the principal. Second point is it's worth considering what would have happened if HP2 had elected to claim equitable compensation for Mr. Ruhan's original breach. It would have obtained no compensation for that breach, but also, because of its election, there would be no account of profits and no constructive trust, because, of course, account of profits is an alternative claim to a claim for compensation. That means that had there been a claim for compensation for the original fiduciary breach, there could have been no constructive trust, and that means there would have been no compensation for any custodial breach of that constructive trust. It further means that there would be no basis for making a claim for dishonest assistance of that breach against Mr. Stevens. Lord, if we go back to the judge's judgment at page 194 of the core bundle, his question at the end of paragraph 278, in the last 2 lines, is, would it be open to HP2 to sue on the second breach without bringing the first into account when arriving at the counterfactual position? His answer to that question is on the next page, paragraph 283. And it is that while the authorities he refers to are not concerned with the position in which the first breach occasions the gain which is then lost by the second, they do support a principle that a claimant with more than one cause of action, some of which cause loss and some gains for the claimant, is ordinarily permitted to advance its claim and its but-for causation case only by reference to those breaches which cause loss. That was his answer to the question. In my respectful submission, in the context of this case, that answer is wrong. He didn't consider the Bartlett line of cases. He didn't consider the question whether a breach could be separate but not distinct. And he didn't consider whether the principles determining whether two breaches are separate and distinct, whether those principles might apply in this case. And the true answer is what we say in paragraph 79 of our skeleton, which I'll invite your lordships to read at your convenience.
79.
79. Lord, if I could now turn to the judge's reasoning, following on from his decision that as a matter as a general rule, it would be appropriate to jerry. If I could move on to paragraphs 284.
Can I just ask you a question around
Yes.
out of what you've been saying? If I don't ask you now, I'll forget it. So forgive me for that. I'm just trying to think through what would happen if Mr. Stevens paid £102 million equitable compensation to the claimant. Common sense would make one think that would extinguish the claimant's claim for that money against Mr. Ruhan, because it would seem inappropriate to get it twice. But because of the claim against Mr. Ruhan is a claim to an account, it's not obvious to me what the juridical basis would be for the fact that if Mr. Stevens did pay this money, if Mr. Ruhan paid it first, obviously there's no loss, and so no claim against Mr. Stevens. But just what you've been showing me has made me think about the alternative. Was what if Mr. Stevens did pay all this money? Why is it wrong that, on what basis is it wrong that the claimant can't then still pursue its proprietary claim against Mr. Ruhan? Because the point you were putting is that the purpose of the constructive trust is to deprive Mr. Ruhan of profits. Mr. Stevens paying the money doesn't deprive Mr. Ruhan of the profits at all. Mr. Ruhan gets to keep them. And I just wanted to say it out loud because it's been bugging me as you've been talking. I didn't know if you were going to come to something like that now. I'm not necessarily expecting
Well,
you to answer it
Lord,
now.
I wasn't, but I'm very glad that you've given me the opportunity to consider the point. I think, I can't believe I'm saying I think. It's not my job to think. In my submission, this is my preliminary submission, I reserve the right to change my mind if I end up in the wrong place. But
Yes.
in my submission, that is a problem. And the reason why it's a problem is because it overlooks the essential interconnectedness between the original fiduciary breach and the custodial breach. It would be wrong to allow a payment made in respect of custodial breach not to be given credit, not to give credit for that payment in respect of the fiduciary breach. But of course, on the judge's view, that those two breaches are distinct. I mean, he didn't use those words.
Sorry, go on.
Well, your lordship may be thinking.
No, I certainly haven't thought through all the possible scenarios, but I wonder whether one does need to identify particular scenarios. I mean, suppose, for example, the money's got to Mr. Ruhan and he still has it. Then there wouldn't be the loss in respect of which Mr. Stevens could be ordered to pay for dishonest assistance. Presumably that would be taken into account in calculating the compensation. So are we rather thinking of a situation in which the money is all gone?
Yes, that's needed for there to be a custodial breach.
So in that situation where the money is all gone, Mr. Ruhan is liable for the money all being gone. Mr. Stevens is liable for the money all being gone. maybe you're, I really haven't thought this through, but maybe you're in the territory of contribution claims or subrogation or something rather than.
Yes, well, perhaps I could say this. Let's say the money hadn't gone. If the money hadn't gone, it was still there in a bank account somewhere in Cayman, and HP2 found it. They would be able to say to Ruhan, you hold that money on constructive trust for me. I'll have it, thank you very much. If that happened, his liability to account would have gone. What that demonstrates, therefore, is that there is an inextricable interconnectedness between the constructive trust and the liability. They're two sides of that same coin. In circumstances, therefore, where the money has still gone, Mr. Stevens pays compensation in equity for the loss of that money. If he pays compensation in equity for the loss of that money, he would thereby discharge Mr. Ruhan's liability for breach of constructive trust, which, by virtue of the operation by virtue of the fact that it's the other side of the same coin, would then discharge Mr. Ruhan's liability to account for the profits. I'm grateful to your lordship for pointing that out. What that demonstrates, in my respectful submission, is quite how inseparably connected all of these breaches are, and how unreal it is to seek to take one breach in isolation and say, I have a massive claim in respect to that breach and I don't have to worry about anything else. I mean, in my submission, it's commutative. Am I allowed to use a mathematical term in order to appear cleverer than I really am? You know, it just as going forward, when it's a claim by the claimant against particular defendants, you can't ignore the impact of a breach in determining whether the claimant has suffered loss. So in exactly the same way, looking at it from the opposite direction, from the perspective of the defendant, you can't where the defendant makes a payment, you can't do anything other than see that as a payment in respect of everything. One payment cancels the lot. And in my submission, that supports my case based upon Bartlett, the Bartlett line of cases, based upon the principle that you can't cherry pick all breaches. They have to be properly understood. They have to be distinct. And there's no case which has ever articulated what the precise test is. It'd be difficult to imagine ever managing to formulate such a test because the circumstances faced by courts are so infinitely various. But whatever the test is, in my submission, we're so far the other side of the line that we don't need to worry.
And just, I haven't thought through this properly at all, talking about the different ways in which one can elect or affirm. The judge is postulating an election to adopt the initial breach, so to speak, so that you end up with an obligation to hold the hotel profits on trust. It's not, you're going for an account rather than loss at that stage. Are there cases in which you can find, as against even the original wrongdoer, an election at stage one, but then a claim for compensation for a consequential breach? I mean, can you separate out your election so that you elect in relation to the original breach but claim compensation for the second one?
I can't say that my learned friends and I have found a case considering that problem. My submission is that it would be unfair, unjust, and unreasonable, were it possible, by doing that, to allow the claimant both to claim the profits and to maintain its claim for an amount 100 million against Mr. Ruhan, and at the same time to claim additional compensation because Mr. Ruhan has committed a breach of constructive trust. That would never be allowed. And that further reinforces the intimate connection between the different breaches and how unreal it is to try. We're only having these debates because there's been a separation of these things, and it's a healthy debate to have. One can see that the principles adopted by Mr. Justice Foxton, in their own terms, they work perfectly well. I don't want to pretend otherwise, but they lead to a result which is absurd.
And I know I think this is aired in the skeletons, and I haven't thought through the implications. So suppose that what the wrongdoer ends up with as a result of his original breach of duty is a painting. And that's therefore, if the principal elects not to go for compensation, then that painting is held on constructive trust for the principal. And the principal then doesn't look after it the fiduciary doesn't then look after it very well, so that it's damaged. Can the principal claim merely the diminished value of the painting on the basis that that's what's now held on trust for the principal? Can the principal claim the diminished value of the painting as the profit and then claim compensation for breach of the custodial duty to look after the painting? Is it alternatively a matter of when you stop the clock, you say the fiduciary has made the profit in obtaining the valuable painting? The principal can stop the clock at that point and say, well, it really doesn't matter what happens after that.
So I'm going to go very slowly when addressing that question. In circumstances where actually, could I say one thing? Adoption doesn't mean, I'll come to this, I've got submissions, I'll be addressing this in a few minutes, but adoption doesn't mean ratification.
No.
So the original breach is still a breach. It's just that there's been an election as to the remedy arising from that breach. In your lordship's question, was the painting bought with profits, or was it the painting that was misappropriated?
I think we'll assume the painting was bought with the profits.
Right.
But it may well be not helpful to explore these thoughts. But you're probably better developing your arguments, and then
very good.
the points may
Perhaps
well fall away anyway.
That's something else I need to go away and think about. There's equitable set-off, and may I make a quick note? May I go to the judgment? I need to think about these and debate them with my juniors who are far more clever than I am. Paragraph 284. So having established in paragraph 280, in my submission wrongly, having established that these are separate breaches which, in relation to which you can ignore the earlier one, the judge goes on, this makes it necessary to consider whether Mr. Ruhan committed separate breaches of his fiduciary duty. In relation to the acquisition of the Hyde Park hotels and in dispersing and failing to account for the proceeds of sale, such that it can be said that HP2 has separate claims against Mr. Stevens for dishonestly assisting those breaches. I have not found the answer to that question straightforward, and I suspect it raises a number of complex issues about the nature and proper characterization of the obligation of a fiduciary with which I have not engaged. However, I've come to the conclusion that Mr. Ruhan did commit separate breaches of fiduciary duty when acquiring the Hyde Park hotels and in applying the profits for his own purposes. And if there are separate causes of action against Mr. Stevens for dishonestly assisting in those breaches, and stopping there, so having made the first area, the error, what I submit is respectfully submit is an error in relation to distinct breaches. He now makes what I submit is another error, which is that he distinguishes between between a breach of fiduciary duty when acquiring the Hyde Park hotels. Actually, later on in his judgment, he clearly means when making the profits. And then in applying the profits for his own purposes. So he distinguishes between making profits and applying them. And in paragraphs 293, for example, he makes the distinction clearer. He refers to the acquisition, retention, and disposal of the profits. In paragraph 2931, he refers to the acquisition, retention, and disposal. And he regards the retention and disposal as matters for the custodial duty, and the acquisition as matters properly within the analysis of the fiduciary duty. Lord, I've already made, your lordships will know what I'm about to say. The essential claim was the same both in the context of the conspiracy claim and in the context of the dishonest assistance claim. The objective was to allow Mr. Ruhan to make profits for himself. In other words, for his use and enjoyment, whether by retention or disposal. And that was a breach of the equitable prohibition on a fiduciary in making a profit without his principal's consent to its retention. That was what was actually pleaded, that there was no consent to the retention of the profit. It was that which allowed the judge to hold. It was open on the pleadings, HB2, to make an assistance of custodial breach claim against Mr. Stevens. And for your lordship's note, it's at paragraph 272, Roman 7 of the judgment, page 190. 272, Roman 7. It's actually letter C. Your lordships will recall the context. There was the question, the judge having produced this analysis in the course of Mr. Stevens' closing, the question then arose, well, is it open to to HB2 to make the claim on the pleadings? Because there was no plea of the custodial breach, and there was no plea of any assistance of the custodial breach. And so in paragraph 272, these are the reasons why he sets out the facts, which allows him to conclude that it was, although not expressly pleaded, it was implicit. And one of the points that he relies upon in Romans 7 at letter C is when dealing with the breaches that were pleaded, the profits breach, secretly making a profit without declaring the same, and without obtaining HB2's informed consent as to the profit's retention, contrary to the rule against directors making an undisclosed profit from the use of company property. And he says that does involve a complaint that Mr. Ruhan failed to declare the profit to HB2 and was not entitled to retain it. Now, the reason why I'm spending so much time on an issue about which I'm not appealing, namely whether it was open on the pleadings for HB2 to make this claim, is because what it demonstrates is that the distinction that the judge made between making a profit and retaining or disposing of it doesn't work in his own terms, because the fiduciary breach, he committed that breach, if analytically it's properly regarded as a breach, by retaining the money when he shouldn't have. That was part of his breach of fiduciary duty. It wasn't part of a separate duty that only sprang up once the constructive trust was in existence. So juridically, in my submission, the attempt, this analysis, which is based upon drawing a very clear distinction between these two processes, the process of making the profits and the process of retaining or applying, and ascribing the making to the fiduciary breach and the retention or applying to or disposing to the custodial breach, doesn't work in its own terms, because on any view, retention is within the fiduciary breach. And indeed, when we talk of the fiduciary's obligation not to make a profit from his position without the consent of the beneficiary, What we mean is not that it's not possible for a fiduciary to do things which generate a profit that then lie in a trust account. The breach is in the fiduciary doing something which results in him having that money in his own account to do with as he sees fit. So what the learned judge sought to do was to limit the scope of the fiduciary obligation so as to allow him to demarcate some territory which he could conveniently identify as a separate breach, which thereby enabled him to run his analysis. And in my submission, that distinction doesn't work on the law.
Going off at a tangent again. So you receive some money, you pay it into a bank account. At that point, you're within the scope of the equitable disability or whatever it is. And then the bank pays you some interest on it. Now, plainly, again, you have to account for the interest on the same principle. That too is held on trust. Merely because it's an accretion to the property that's already held on the trust, or it simply is an application of the general principle? It's
a profit he makes from the breach. If I breach my fiduciary duty to you and make £100 million profit, and I put it in an Investec account and turn that into 110 million, I'm liable to account to you for the 110 million. One doesn't need to plead some separate breach as a result of which you can claim the extra 10 million. So, just drawing some threads together just before the short adjournment. Summary of my argument. First of all, I say the judge's analysis is based upon a fallacy that the breaches and their consequences in this case are so distinct that they can be ignored and that one can cherry pick for the purposes of assessing loss from any one of them. Secondly, I say there's another fallacy in that the judge seeks to make distinct distinctions in the actions and seeks to characterize them as being different kinds of breaches in circumstances where they're all part of the original fiduciary breach. And so when the judge, with commendable candour, characteristic candour in fact, says he suspects it raises a number of complex issues about the nature and proper characterisation of the obligations of a fiduciary. Well, in my submission he was right, and he did overlook that fundamental point. Lord, I see it's 5-1. I was going to move on to the judge's reasons for holding that it would be appropriate to adopt his analysis. I wonder if this is a convenient moment.
I'm happy to break on that basis and to come back at 5-2.
All right.